Introduction to Legal Profession. Why do we have this class? This class, Legal Profession, is required. Why? Many students think that it is required in order to prepare you to take and pass the MPRE, the Multi-State Professional Responsibility Examination. And indeed, this class does aim to do that. We cover the rules of professional responsibility. We have practice multiple-choice quizzes. The final exam includes multiple-choice questions patterned on the MPRE. The MPRE is given by the National Conference of Bar Examiners 3 times each year, in August, November, and March or April. State bars generally require you to pass the MPRE as well as the state bar examination before you are sworn in as a member of the bar. In Utah, your passage of the MPRE must be within 2 years before being admitted to the Utah bar. Accordingly, you may take the MPRE while still in law school. However, we do not require you to take this class in order to pass the MPRE. Indeed, the requirement for the MPRE and the requirement for this class come from the same historical event. The requirement for this class stems from Watergate. The Watergate scandal involved the president and some of his staff, most of whom were lawyers, mounting a cover-up of a break-in during and following the campaign for president. Leaders of the bar were horrified that lawyers should be involved in such illegal and dishonest activities. As a response, the bar sought to require all applicants to the bar to pass an examination in professional responsibility. The bar also decided to require all students to take a class in professional responsibility. From that history, one might imagine, then, that this class is intended to instill ethics and morality in lawyers to be. But is that possible? Didn't you acquire your sense of morality, of right and wrong, at an early age, influenced by parents and perhaps religious teachings? And what credentials do law professors have to preach ethics or morality? I don't aspire to be a moral leader or a philosopher of ethics. However, we will try to make you feel and think about morality and ethics in this class. Sometimes, often, what you feel is the morally right thing to do will be what the rules of professional responsibility mandate. And sometimes, just as in your personal life, it will be difficult to do the morally and professionally right thing. Your client or supervising attorney may be asking you to do something dishonest, and you must decline or even resign. But sometimes the lawyer's professional responsibility clashes with your feeling about the right thing to do. As a moral citizen, you would turn in someone whom you know is guilty of a serious crime. But as an attorney, you have a responsibility to maintain a client's confidences. Finally, sometimes the rules of professional responsibility offer you choices about how you handle moral questions. In this class, we will learn what the rules of professional conduct require lawyers to do and what they forbid lawyers from doing. There are many clear rules. Do not let your experience as a 1L cloud your mind with the idea that everything is gray, that anything is an arguable proposition. We will also learn the law of lawyering beyond the rules of professional conduct. This will encompass other court rules that require lawyers to behave in a particular way. It will include standards for legal malpractice, the court's power to hold an attorney in contempt, an appellate court's ability to reverse a criminal conviction for ineffective assistance of counsel or for denying a client due process of the law of fiduciary responsibility, and the law of agency, as the attorney is a fiduciary for her client and the attorney is an agent for his client, the principal. All laws and rules that frame how a lawyer must behave contribute to establishing the law of lawyering. Then, I hope we can reflect upon how it feels when we, as lawyers, are required to do something which conflicts with our morality as persons. How will we handle this? More importantly, I hope we can reflect upon how we will make moral choices when the law of lawyering gives us that choice. Where does the law of lawyering come from? There are various players that establish and enforce the relevant law of lawyering. The state Supreme Court has the ultimate authority over the rules of professional conduct. The court adopts the rules, admits lawyers to practice in the state, and disciplines or disbars lawyers. Unlike other professionals who are licensed and disciplined by a state agency, the courts have authority over the practice of law and thus over who is a lawyer and how the lawyer must behave. The state Supreme Court typically delegates authority to the State Bar Association, a quasi-judicial agency, to establish and administer bar exams, to investigate and prosecute lawyer misconduct, and to opine as to the meaning of the rules of professional conduct. And of course, the state Supreme Court establishes the law of lawyering in other ways, by adopting rules of procedure, rules of evidence, and by interpreting statutes or making the common law in areas of law relevant to lawyering, for example, defining legal malpractice or ineffective assistance of counsel. Courts further shape the behavior of lawyers by their day-to-day rulings, denying or granting motions, ordering attorneys to take certain steps in their cases, and even holding lawyers in contempt or fining them for filing frivolous pleadings. So, what is the ABA? The American Bar Association is a club, a voluntary association. It is a very powerful organization, however, and has undertaken to write the model rules of professional conduct. The ABA first drafted a canon of ethics in 1908. In 1970, the ABA adopted the Model Code of Professional Responsibility, which contained clear rules as well as more aspirational standards, ethical canons. Both the canon and the Code of Professional Responsibility are usually included in rule books to show the history of the current rules. In 1983, the ABA did a wholesale review of the code and adopted an entirely new document called the Model Rules of Professional Conduct. That document was overhauled again by the ABA in 2000. There are minor amendments proposed annually by the ABA. What we will study, and what is examined on the MPRE, is the current version of the ABA Model Rules of Professional Conduct. Currently, Utah's rules of professional conduct are very similar to the model rules. However, each state is entitled to adopt the rules it sees fit, and many states have made certain changes to the model rules. The MPRE folks state that their questions call for answers that are correct in any jurisdiction. In this class, we will occasionally note when Utah's rules vary from the model rules in significant ways, since many of you are interning or clerking for attorneys in Utah and may benefit from this knowledge. What does it mean to be professional? What is a profession? Who is a professional? According to Roscoe Pound, professionalism is the practice of a, quote, learned art in the spirit of public service, close quote. This is the definition adopted by the ABA Commission on Professionalism. Sociologists define professional occupations as those requiring technical competence and carrying ethical obligations. Other distinguishing features include ethical codes, regulatory autonomy, prescribed training, and monopoly. Elliot Friedson, who is also quoted by the ABA Commission, says a profession requires substantial training and the use of complex judgment, that clients cannot evaluate professional services and so must trust the professional. Accordingly, a profession must be self-regulating and the professional must be devoted to serving the client and the public. What criticisms are levied against the legal profession? There are various criticisms of professionals, including that the restrictive practices limit entry, discourage competition, and stifle innovation. Professionals are criticized for being paternalistic and inappropriately deciding what is best for their clients or patients. It is argued that the paternalistic power can motivate professionals to create and mold client needs to their, the professionals, own ends. Moreover, the legal profession is criticized for failing to be available to the general public. While corporate entities retain lawyers, individuals find it difficult to afford to hire an attorney for legal representation when they need it. From divorces to wills, the general public is increasingly approaching law as a do-it-yourself project. If the legal profession cannot make its expertise available to those who need it, it is unlikely that society will permit the legal profession to retain its monopoly power and self-regulated state. The general public's views of lawyers is very low. According to Deborah Rohde's book, In the Interests of Justice, less than 1/5 of Americans have confidence in the honesty and integrity of lawyers. For class discussion, consider the public's dislike of lawyers and what you, as a professional, will do about this. Why did you want to be a lawyer? Does your motivation still make sense to you? Have you come to think less of the legal profession? Why? Have you reassessed what the legal profession will offer you and how you will carve out a place in the legal profession? Thank you.